morning. I'm Professor Lynne Kramer at Touro Law School, proud to be a professor there. And I spent over 30 years in practice myself, trying cases, having started my career in the area of criminal law. And so tonight I have with us my very good friend, Tony LaPinta. And Tony, I would say, is without a doubt, and I'm not just making this up, Tony is thought of as one of the top criminal trial lawyers in the entire state of New York. And Tony, I am thrilled to be able to spend this time with you tonight.
Thank you, Lynn. Thank you very much. I'm glad to be here and always happy to help you too.
Well, the topic tonight has to do with representing unpopular defendants and how and why a lawyer like yourself would do such a thing. And I thought that it might be interesting to start with the Valva case, which you got involved with. And so I have two questions for you on that. One, if you wouldn't mind, because I don't know how much of the audience knows about this case in depth, although it's been in the news, obviously. So if you could give us a little bit about the Valva case and tell us why on earth you would volunteer to take on a case of that nature, where there's no real serious remuneration involved. So, Tony, all you.
Sure. So let me begin by telling you and explaining the facts of the case. So Michael Valva is 44 years old. He's a former New York City Police Department officer and was born and raised on Long Island. He was living in Center Moriches with his fiance and his three children, boys, ages at the time 10, 8, and 6. Two of the boys, the two oldest boys, were autistic, and he was living with his fiance and her three daughters. It was kind of a blended family situation, kind of like a Brady Bunch.
Well, not exactly.
It wasn't a Brady Bunch. So what happens here tragically is this couple had no ability to care for the two autistic boys. They had severe behavioral issues. They had severe health issues insofar as being incontinent, and really required just a delicate, loving environment for them to thrive in. And they didn't receive that. So to combat the steady urination and defecation in the house, Mr. Valva's fiance, Angela Polina, mandated the two boys to sleep in the garage because she was very tired of having to throw out rugs and comforters and mattresses and pillows and blankets. But this stint in the garage extended over a 1.5 year period of time, including the winter months. And tragically, on a January cold night, the subsequent morning, young Thomas Valva, the 8-year-old, passed away of hypothermia.
Tony, let me just interrupt you for a minute, because your presentation to an extent made it sound as if Mr. Valva had no involvement, that Angela Polina made these children sleep in the garage. But I mean, he certainly had choices that he might have made.
Well, she was the impetus, the driving force behind that. And he did fight it for a while. And it's clearly in the record by virtue of text messages, emails, that he really fought it hard. But eventually he bought into it and was actively a participant in having these boys stay in that garage. They weren't allowed out. They weren't even allowed to use the bathroom. They were only allowed to use the outdoors to urinate and defecate, and clearly was an active participant in this murder. So I did not mean to minimize his role, but the genesis of this whole horrible scenario certainly was Angela Polina.
Okay, so you mentioned the incontinence issues. But from my understanding of the case, I mean, these children were not fed properly either. I mean, they were scavenging in garbage and at school came in hungry, et cetera. Teachers had reported to CPS, that's Child Protective Services, that these children were hungry, not clean many of the times when they arrived at school, et cetera. So there was more than just sleeping in the garage involved, no?
There was, yeah. So there were a number of charges involved. The top count was murder in the second degree. However, not the theory of murder that we're most used to learning about and reading about. This is not an intentional murder case. This was charged under the doctrine of depraved indifference murder, meaning that the conduct that caused the death was highly, highly reckless, but not intentional. The other crimes involved endangering the welfare of a child, which included improperly feeding them, inadequately feeding them, improperly clothing them, which was also part of the indictment as well. So it was a whole, bunch of different facts and circumstances, basically involving the mistreatment and care of these two poor autistic children.
Sort of a house of horrors for them.
Well, that was the prosecution's term. Yep.
I mean, however you want to look at it, I mean,
Yeah.
clearly they were young children, so couldn't be, I mean, this wasn't something that they could take control over.
Yeah.
In any event, Tony, let me ask you, because this is the question that, I'm sure you've been asked so many times during your career, but why, knowing many of these facts were undisputed as far as what happened to these children, why on earth would you take on a case of this nature? I'm assuming, knowing that the client is responsible in large measure, in some fashion or other, for the death of his son.
Sure. So let me just tell you, Lynn, let me start off with the answer by saying that I have an unconditional respect for our system. I do. I believe our system works as best as any system does. And everyone, no matter who it is, whether it's an angel or a devil, is entitled to a fair process, no matter what the facts are. I am wholly committed to that. And the reason why I decided to come on to the case was Michael Valva was indigent. He did not have any resources to hire a lawyer. It's one of the facts involved in this case. He did not have an ability to just get up and move out of that house with his kids. He had no finances whatsoever to do that.
He was a police officer, though, right?
He was. And, he was working as hard as he could, making overtime, but every cent that he was earning was going to his various expenses. So the point is, there was no, and when you're indigent, you have the right to assign counsel, free counsel. And in Suffolk County and Nassau and the entire state of New York, they have a homicide panel in each county that if you have certain qualifications and experience in homicide cases, they'll assign you a homicide case, and the county will pay a meager hourly rate, and you will be representing an indigent defendant on that charge. So there was no assigned lawyer that would take this case. Mr. Valva appeared in court after he was indicted 3 times, and no lawyer wanted to stand up for him.
So let me ask you, because my recollection is John Laturco, another really top trial attorney, agreed to get on the file. How is it that he got both of you?
Well, John and I had spoken to each other. We've known each other, have been friendly for 30 years. And we were both troubled by the fact that no one would step up and represent this man. We were actually really upset over it. So we spoke and we agreed that if we would both come onto the case and work together, that we would do it as assigned counsel. We haven't been on the assigned counsel homicide panel probably over 15 years now. But we agreed
because you have plenty of paying cases and you didn't.
Yeah, I mean, our practices, thankfully have elevated, and we are gifted to be able to charge good rates for our time now. So, but we called each other, we spoke, we thought about it because we knew it was just a tremendous undertaking of time and commitment, and we agreed to do it. So John and I were co-counsel, and on the eve of trial, we were able to get a third lawyer on the case, Mr. Capone, Sabato Capone, who has a long career as a legal aid attorney. He was retired at the time, and we took him on board to help organize a defense, and the three of us went forward and tried the case.
So this individual who was charged with, and I know it sounds a little harsh from my vantage point, but I've been asked these questions. This guy who was charged with this behavior towards his children ended up with three of the most experienced and top attorneys in the county without paying, right? While somebody else would never be able to hire all three of you, right?
That's correct.
And
Now, let me just tell you this.
yeah,
Prosecution had a lot more than three lawyers. Had a whole homicide bureau of detectives working on this case.
but that's true in most murder cases.
Well, I'm going to tell you not. They put more detectives on this case than they typically do. This was a case like no other regarding police work. They were hands-on and continue to be hands-on for the 3 years that it took to try this case. So yes, Lynn, you are right. He had the benefit of three experienced lawyers, and many defendants don't have that opportunity. But if you want an equal battlefield, we try to make it as equal of a battlefield as possible.
So look, Tony, you did it, it sounds like, because you believe in the system and feel that everybody is entitled to a defense.
Absolutely.
But did you, in your own mind, feel any discomfort about defending somebody who had done something like this to a helpless child?
Sure. I'm human. I'm a father. I love my family. I love my daughter. Of course, this is a troubling case. You'd be subhuman if you didn't have feelings about it. But if every lawyer would be reactive to his or her emotions, you wouldn't have many lawyers standing up on cases that are bad fact cases that the media is all over, and the system wouldn't work the way it does. So yes, I will say that, but I will also say that over the 30 years that I've been doing this, I've had a good ability to put my emotions aside and to really focus and really work hard to preserve people's rights, to protect our system of justice, and to show that everyone, including Michael Valva, is entitled to good legal representation.
Has there ever been a case that you said, enough is enough, I can't handle this, this is not something I want, this is not someone I want to represent?
No, I haven't. I don't know whether it's luck of the draw or not, but there's been cases that have been problematic to me factually, emotionally hurtful to me. But again, I've been able to, and it's taken some time, I've been able to separate my emotions from my lawyer skills and my ability to focus and concentrate on helping people. So I haven't yet. I may.
Well, you asked me, we were speaking earlier, and you said to me, hypothetically, if Donald Trump called me tomorrow, would I take the case? I had my answer to you. What's your answer to that question? And politics, that I'm not basing it on, what party you happen to be active in, et cetera.
So I will tell you that I am not a Donald Trump supporter, and I am really proud to tell you that. I have no qualms of even saying that politically. I have a lot of adjectives to use about him, but I'll tell you, I would represent him, and I'll tell you why. For the same reasons. You can't have a screen when you do this. I just believe that. If you have a screen, criminal law is not the profession for you, in my view. I respect people that do. I have no problem with that. But Donald Trump is deserving of a great defense just as much as anyone else did. And I don't know all of the details of the facts involved in the case, but there's certainly optics involved here as to whether it's a legitimate charge, the timing of the charge. Now, I happen to know his lawyers. I've had cases with all of his lawyers. Todd Blanche, who is spearheading the defense team, is a lawyer who I've known for many years. He was chief of the the gang unit in the Southern District of New York for the Department of Justice. He left his law firm, probably making a ton of money, to take on this case and to defend Donald Trump. And his position was, you may not like Donald Trump, but you got to step up and you got to represent somebody as best you can, because that's what they're entitled to. Every single one of us, Donald Trump, Michael Valva, whoever it may be, is entitled to a fair system and a great lawyer. That's my view.
Well, Tony, let me say this. I mean, when you and I spoke, I said to you I would not.
Mm-hmm.
For the reason that I believe every defendant is entitled to a zealous defense. And I simply am not capable of providing that zealous defense for some people. Does that have any logic to you? Can you understand how somebody can say, I can't do it?
Totally.
Not that I don't believe in the system, but in a sense, it's how I believe in the system, because he is entitled to, as every defendant.
I totally respect that, and I understand it, and I get it. And look, we're not robots, right? We are creatures of emotions. We react to different things at different times, and we all have levels of tolerance, and our emotional levels are different. So, you know, I get it, but I'm devoted. I'm in it for
the real deal,
for good reasons, and I'm happy to do it. And I'll accept the criticism, and I'll have a lot to say about it. I'll defend my position to the nth day, and I'm ready to rock and roll.
Well, has any of this? I know you have a daughter of whom you're very proud. Has any of this ever impacted your family? The fact that you're representing people that other people just think are horrible, and they say to your daughter, how could your father do that? Has she ever had experiences? Has it impacted your family in any way?
I'm sure she has. When she was she lives in the city now. She went to college in Washington, and she grew up on Long Island. I'm sure that she's had people, friends, parents of friends, and teachers comment on my cases over the years. But at a very young age, I instilled these insights into my daughter and understanding the system. She gets it. She understands it. You know, she's troubled by the facts as well. Anyone would be. But she's LaPinta's daughter, so she gets it.
Well, clients, I mean, this is not a shock to you, and our listeners will see, but let's be honest, clients are not always truthful with us as attorneys. I mean, one of the things that I've experienced many times is a client who is being dishonest. I will tell you and our listeners that my last day of accepting criminal defense cases, and I was on the panel as well, was the day that the first gentleman I was assigned. I spent a good time examining and asking questions about the crime. He said he didn't know the car that he was using was stolen. And of course, by the time I finished questioning him, it turned out he had to hotwire it to get it to go. So I think he knew more than he admitted to. And the second assignment that day was the judge looking for me to represent somebody who was burning swastikas on lawns. And that's when I recognized that just, for me, and that's not a lack of belief. It was a lack of, I just couldn't do the zealous thing that I mentioned to you earlier. What happens to you when you meet clients, and I know you interview them at length, when you hear a story and, quite frankly, I'll use a nice term, you think it's horsepucky? How do you handle that?
Yeah. So look, you have to address it. You can't just ignore it. So it's a process. When you come across a client, you have to develop a rapport. You have to develop a trustworthiness with that person. That person has to feel utterly comfortable that you are there unconditionally to help. Now, there are times that it happens that just facts don't make sense. And there's a number of ways to deal with it. you know, you could address it right up front and say, this doesn't make sense to me. I need to know these facts as accurately as possible. That's the best way that I'm going to be able to represent you. I'll go as far as to say that I need to know the bad facts even more than I need to know the good facts, because I need to be able to understand what the prosecution and the police are going to say about this. You could transpose it a different way, right? The prosecutor, you were the prosecutor in this case, Mr. Client. What would you say about this case? What would you argue about your guilt? And what would your response be to those arguments? So it's a process. I don't know if I'd call out a client upon initially meeting the person. You know, there's a lot that goes through the process of interviewing a client, learning the facts and circumstances of the case. The Valva case had a long, long history, and it wasn't a defense of innocence, Lynn. Please know that, right? So under this doctrine of depraved indifference murder, the issue of depravity is heightened recklessness, very, very, very reckless conduct. It always lends to a legal argument that it's not depraved, that it's merely reckless under the statute. In other words, it goes from really, really reckless to reckless, which is an affirmative defense. You're not saying it didn't happen. The Valva defense basically didn't oppose most of the facts, right? What we argued, and I thought that we had some decent derivative evidence to support the fact that Michael Valva, you know, didn't, and depravity is hard to define as well, right? You could basically say that you don't care if somebody lives or dies. The conduct that you undertake is so depraved and so recklessly awful that you don't care if someone survives or lives. That just wasn't the case with Mr. Valva. It just wasn't. You know, he acted horribly. He did stuff that defies human emotion, sentiment, and the care and need for a child in your life. And what he did was not excusable, but arguably it wasn't depraved indifference murder. And so we didn't have that problem with Mr. Valva. He was actually very forthcoming and very blameworthy of what happened. He didn't shield any of these facts. We didn't think that he lied to us. There were certain facts in the case where, you know, it was more difficult for him to explain than others.
Well, there seemed to be a little blame shifting too.
Well, and rightfully so. And rightfully so. I mean, there's plenty of evidence in that case to show that Mr. Valva fought this off for a while, and up to—
But he didn't have to choose to stay with her.
All right. No question about it. He had options. He's a police officer. There's just, you know, tons of resources that were—
Well, that's what I'm thinking. He's not your average, you know, when you talk about indigence. And again, I mean, there's indigence and there's indigence. This was a man who had been employed as a police officer for years.
Right.
And they do have resources, because we know that police officers struggle sometimes because of the difficulty of their job.
Right.
And so part of his, you know, is the guilt of putting that relationship, or whether you're going to claim it's finances or whatever, ahead of the interest of his children, right?
You know, so it's interesting because you read these facts, you watch just the incredible blitzkrieg of media that was on this case.
Sure.
You have an image of who Michael Valva is, personality, right? A demeanor. Instinctively, you're going to think that he is arrogant, he's nasty, he's emotionless, he's cold. Nothing of the sort. You know, if you didn't know Michael Valva was Michael Valva and you met him, you probably like him. But just what evolved in that house over the period of time, given the relationship with his fiance, given his history of fighting for these kids in a matrimonial case, custody-wise, and the finances he was going through, it just developed in a situation where he just took part in acts that just, he himself will tell you, I don't know why and how I did that. So it's a tragedy. It's something that'll stay with me forever. It will, and it will stay with everyone forever. You know, I know the prosecutors on that case very well. I think very, very highly of all of them. Carrie Ann Kelly I've known for 30 years. She is a wonderful person, a terrific trial lawyer. I know that this case will stay with her forever. She put her heart and soul into this case. She did a terrific job. My hats go off to them. They were very honorable attorneys. They were very respectful. It was really, Lynn, I must say, the model of professionalism in that courtroom. You know, we fought the legal battle. We were all well prepared. We executed as good as we could, and we left it all out on the table. And the jury, I thought, because I interviewed them afterwards, I thought they did a yeoman's task. You know, it wasn't easy for them to go through the facts of this case. There were times when spectators and court officers and jurors and were crying during the testimony. You know.
Well, actually, you know, when you mention the topic of jurors, because that to me, this case was all over the papers.
Yeah.
Did you have difficulty finding jurors that you felt would be impartial on this case?
Well, I'm going to tell you, out of the hundreds and hundreds of jurors that were summoned for jury duty, I don't know the exact percentage, but I'm going to say probably there's only maybe 5 to 7% of them that agreed to stay on to be interviewed on the case. The vast majority of them, right up front, made it very clear that they just couldn't sit as jurors in this case. They've made up their mind. They were so emotionally damaged by it that they just couldn't feel as though they'd be fair. And hats off to them to do that, because that's what lawyers want to know when you pick a juror.
Right.
You don't want a juror that is embroiled in emotions. Emotions are poison in the criminal justice system. They just are. You need an honest, uninfluenced view of the facts to determine, you know, issues and guilt or innocence. So I thought the judge did a terrific job in jury selection. It was one of the toughest jury selections that I ever did. And I thought our panel was a good panel. I still think our panel was a good panel. I met with them. They were so respectful. They really were. They were respectful. They shook my hand. They acknowledged the hard work that we did, and they had questions. They really thought about it. They honed in on the issues that they needed to hone in on. What's maddening sometimes is when you speak to a jury after a verdict, and they'll tell you about a set of facts that they dwell on that really had very little to do with the case. Not here. They were focused. They were a good panel. I can't speak about the Polina panel because I wasn't involved in that trial, but the Valva trial, I'm so glad that I spoke to them, because after I did, I truly emerged thinking that the process worked and it was as fair of a trial as you're going to get. I did.
So a lot of our listeners are not aware of how jury selection works. You know, I cavalierly said, you know, could you find a fair jury, et cetera, et cetera. But there's a lengthy process in our state court system in terms of jury selection. How is it that you could ask questions, or what questions did you ask in order to ascertain that people would be open-minded and fair? And could you make suggestions to them at the outset of things that you wanted them to promise you to do during the course of the trial?
Sure. So, look, picking a jury, in my view, is if not the most important step in a trial, right up there. And jury selection is really, it's the art of advocacy from the onset. That's what I've taught over the years with students, is it's advocacy from the onset. From the first time you open your mouth when you meet a juror, you are being an advocate, but in a way that's going to achieve a number of things, right? One, you want to make sure your jury is fair and impartial. Those are the buzzwords, right? They're not fair and impartial, they shouldn't be on your jury. They can't have preconceived thoughts. In this particular case, there are a couple of different issues that we thought were paramount in addressing with jurors, right? Do they have autistic children? Are they grandparents? Are they parents? Do they have, are they single? Are they school teachers, right? A lot of the witnesses in the Valva trial were school teachers from the Center Moriches School District, right? We want to know if any of them have relatives who are law enforcement officers. And that's a biggie in any trial, because not only do you have Suffolk County Police Department, you got Park Police, you got East Hampton Villages, Amityville, Nassau County and NYPD officers that are allowed to live on Long Island. You got a lot of police officers and families of law enforcement on Long Island. I want to know that. I want to know who in your family are police officers, what roles, what departments do they work with, what bureaus, what kind of cases, because you know what happens. You know, your husband's a cop and you're having dinner, you're talking about the day, you're talking about the arrest, you're talking about a trial the cop testified in. But the biggie here was just emotion and an ability for a juror to put aside your emotions, because you know that everyone has emotions about the case. And could you harness your emotions? Could you put them aside and look at the facts purely based on the factual allegations and don't have emotions impact on it? I think, I think by and large, the jury did that. There were two jurors that were crying consistently during the trial. And they didn't want to meet with the lawyers, and we respect that. But, the 10 of them that we did meet with, I'm assured and have a great sense of confidence that they really did do a good job and evaluate this case as best they could.
So we seem to tell our students something different. Usually we're on the same page, and you're talking about impartial jurors. And I say, when I'm doing it, I'm looking for somebody who's going to root for my team. Is that something that you find appalling, that I would say something like that?
Not at all. And that's what I mean by advocacy from the onset, right? So fair and impartial, what I mean I found impartial is someone that's going to look at a defendant sitting at a defense table and saying he's guilty before hearing any type of evidence that the police and prosecution have, right? A lot of people think if he's indicted, he's guilty.
Smoke this fire, so to speak.
Right. So, but once you have someone who can give you that commitment, then you kind of work it a bit, right? You're gonna talk about certain facts of the case. You want to expose your warts, your bad facts, and you want to promote your stars, right? The good facts. And to do that in an emotional setting like the Valva trial, where you want to achieve so much in such a limited time of jury selection, is not easy. So you gotta be instinctive. You gotta be reactive to jurors' answers. And when given an opportunity to kind of talk about a subject in a way that advances your case, you do it. So yeah, of course, at the end of the day, you want a juror that's going to be following you. You want a juror that's going to be believing in you. You want a juror that's going to like you. And you don't have much time to do it, right? And these are strangers. You don't know these people at all. You have a questionnaire with general inquiries about where they work, if they're married, if they have children, degrees, education, work history. Not much. But I would agree with you, Lynn. You want to have a jury that's going to follow you. And in a case like this, not easy to do. No one started off rooting for the defense in this jury. But
what kind of stars? You mentioned you would promote your stars. What exactly were the stars in this case?
Stars in this case was that Michael Valva really did fight off the demands of his fiancée for quite a while with his kids being in the garage. He would bring blankets and pillows and food for them in the middle of the night when his fiancée was sleeping. There were text messages back and forth when he was working. He's working the night shift, where Paulina would be telling him about his son's urinating in the garage, and he'd be defending his kids, right? The problem is, over a period of time, whether it was because he just was fighting a losing battle or he became as frustrated as his fiancée did, he bought into what she was doing. And that's when it turned bad for him. But again, depravity, do you care whether somebody lives or dies? To the end, I truly believe that he didn't want his son to die. I really do.
You actually brought in a hypothermia expert in this case.
Yeah,
and there was testimony about the boy being hosed off in the cold, right? Afterwards, and then put in a hot bath, if I'm not mistaken, and you can correct me if I'm wrong on that. But could you explain to our listeners and viewers what that whole hypothermia expert was about?
Sure. So the facts are detailed and complicated, but put as simply as I can, the boy was brought outside. Thomas was brought outside that morning that he died. He had defecated in his pants, and his father brought him outside and washed him off outside. He then brought him back inside.
What was the temperature, if I can interrupt?
Well, the low temperature that night, I think, was 19 degrees.
Okay, so it was really cold when he brought him out there.
It was cold, no question.
Okay.
So he then brought him down into the basement, and Valva's position, and I believe it's true as well, gave the young boy a bath. And the argument is that it was the sudden change of temperature for him being in the garage overnight, being outside, and then the warm bath, the sudden change in temperature is what caused the poor boy cardiac arrest, which eventually is what he died from. So when you die from hypothermia, you die from cardiac arrest, right? So and we had an expert from Alaska, actually, who is one of the top experts in the world on hypothermia, who was able to explain the body function of what happens when your body gets cold, and how, your neurological system kind of shuts down on you, and consequently your organs start shutting down on you, and your heart rate goes up and your heart fails eventually. And that was precipitated when there's a sudden change in temperature. For example, you ever wash a glass in hot water and then put something cold in it, or vice versa? You have a frozen glass in your freezer and you put hot water, it's going to shatter, right? Similar effect to the human body. Your body cannot control sudden shifts in temperature. And our argument was that it was the benevolent act of bathing the young boy that caused his death, and not the fact that he was exposed to cold temperatures overnight. Now, the prosecution has a different theory. That their theory was that he never was given a bath, and that was just totally made up. I don't believe that. I believe that he did. I believe that.
But wouldn't that have been evident on his body? I mean, if when he was recovered, deceased.
Wet. Yeah, no, he was wet.
Clean or not clean? I mean, wouldn't that be obvious?
Well, he was clean. He was perfectly clean. Yeah, he was perfectly clean. And the EMTs that arrived that dreadful morning had the boy wet. Now he could be wet from being cleaned outside, but his hair was wet. There was towels in the basement. So I really do believe he was given a bath. But at the end of the day, and these are how insightful the jurors are, right? One juror said, well, it was pretty bad of him, pretty depraved of him to put his child in a warm, hot bath when his body temperature is 76 degrees. And in their mind, the act of doing that was depravity. So
we're showing it the other way, trying to say this is a good guy. I mean, he was trying to do a good act, and therefore he wasn't depraved. And some of them actually viewed it as quite the opposite. Interesting.
Now, is that a means to an end? Look, it is what it is. But jurors, I have to tell you, they're quite insightful, and they do think about stuff. And we spent 3 years with this case. This was a COVID related matter, so we were stuck in a standstill for a long time with this, and we spent an awful amount of time going over the facts with Mr. Valva, researching it, finding an expert. So we knew these facts real well. And still, no matter how well you know the facts, there's still an angle or a view that you never think of. And it happened a couple of times during the trial. So it really was a case that will stay with me forever for a lot of reasons. I do think of Thomas Valva quite often. I do. And I could still feel heartbroken about Thomas Valva dying, and still feel positive and accomplished as a lawyer and giving Mr. Valva a fair trial. I could do that. And I don't think I am doing anything wrong by that, quite honestly.
Oh, that's a bravo on your side. I have no problem with it, Tony. Just because
a lot of people have a big problem with it.
I know that,
and I get it. But that's emotions taking over, and we got a lot of comments from citizens really angered at us for taking the case over and for fighting for him. But listen, we expected that. And we tried to use this whole process. We dealt with the press on a daily basis. They were there. I mean, they were swarming all over this case. So every time we had an opportunity to address the media, we thought it would be a good idea to be consistent in our position that this is a perfect example of how and why everyone needs good representation, because people have instinctive feelings and emotions and reactions. They wanted him convicted without even knowing all the facts. And once again, I know I'm repeating myself, there's a logical argument, a good faith, logical argument between depravity and recklessness. Our argument was it wasn't depraved murder, it was reckless manslaughter. That's a good faith, good argument. I don't care what your emotions are about the case. Under the law, that's a good faith argument. That's not that's not just grasping at straws here. And there were certain facts in this case that really, in our view, bolstered and supported the fact that it was recklessness and not depravity.
He was going to be guilty of something. It was just which charge. Tony, I'm going to just finish up on Valva with a question, and I know there's a lot of sensitivity on this particular point, but I do want to raise it with you, and that is the exposure of the social services and perhaps that area, because you're talking about how effective you found the legal system to be. What view, if any, do you have with regard to how effective the Child Protective Services system was? And again, I'm not here to criticize or anything else.
Right.
My hope is we always learn things from situations. But honestly, and I spent a lot of years in this field in particular with abused children, et cetera. In terms of the fact that teachers had reported a variety of people, unless I'm mistaken, but the facts indicated to me that there were several different reports of abuse of Thomas. What do you think in terms of how the system either helped or failed this family?
The system clearly failed Thomas Valva. There's no question about it. No question about it. I've gone through every note and record that CPS made in this case. I went over every note and record that the teachers from the Central Mauritius School District made on this case. And I feel amply qualified to say that the system failed Thomas Valva, clearly. Now, why did it fail? There could be a number of reasons. My opinion is that the Valva Paulina residence, it was termed a house of horrors. In reality, it was a beautiful house, a beautiful house. You would walk through this house and you'd see artwork that the kids had from school on the refrigerator. We walked through the house when we were hired. We did a walkthrough, we photographed it, we videotaped it. So I know that house very intimately. The refrigerator was packed with food. There were flowers on the kitchen table. There was artwork. There were abundance of toys in the backyard. There was a pool for the kids. Their rooms were stacked with clothing. They had advanced electronics. I mean, you walk through this house and it is it's bountiful, and the optics were nothing close to abuse taking place.
So those were available to some of the children, just not all of the children.
Well, yeah, but when you walk through the house and you see it, you're not
right. I understand, of course.
And a lot of times, Lynn, and you know this, you go through some of these homes and it's just human tragedies what people live in and what children live in. So the other issue is Michael Valva being a police officer in and of himself, right? And I will say, however much my heart breaks, for the Valva, Mrs. Valva, the mom, she didn't help herself in that family court litigation. That there's reasons why she lost custody of those boys. That had something to do with it as well. And quite frankly, Valva and Paulina were not truthful in their interviews with CPS. Now, I will say, from my point of view, I don't think the teachers at the Santa Maria School District did anything wrong whatsoever. They actually were very, very copious in their note-taking. They were very thorough in their reports. You know, these teachers, they saw these kids on a daily basis and did everything they could, absent writing to the police station themselves and speaking to police officers themselves and being complainants themselves. But no one has an obligation or duty to do that. They did everything that they.
Well, the normal process is to report to CPS.
Right.
That's how teachers
Right.
are.
Right. Right. So I don't think they did anything wrong. Now, I mean, I have some thoughts and opinions about their testimony in the trial, but that's neither here or there. The point of the matter is the system did fail Thomas Valva. How and why it did, I just touched on. So I would hope and think that there will be some big changes made. Caseload is a big deal here. These CPS workers have tons of these cases and little time that they could spend on them. They're
not well paid.
They're not well paid. There's an article in today's Newsday about Nassau County elevating their pay for CPS workers to attract more qualified, educated workers. So there's things that can be done to avoid this happening again. And hopefully it will never, ever, ever happen to another child again.
Tony, before I know that we've spent some time, I said that we would spend a few more minutes on more general discussion. And I really appreciate everything that you shared on the Valva case, because that probably in the history of this county is one of the most notorious cases. We had the Amityville horror and we had the Pelosi trial, but there really are very few that have this type of press, et cetera. So I do appreciate your explaining a lot that many of us were not aware of, certainly many of our listeners and viewers. I want to ask you a couple of questions, not specifically directed at this case, but I mentioned to you earlier about truthfulness of clients, and sometimes we run into people not being entirely forthright with us. How does it work, Tony, when you have a defendant who wants to take the stand and they don't want to tell the truth? How's that all work out? And what is it that your obligation is as a lawyer? How's that work?
Yeah, so luckily I've never encountered it myself. I haven't, believe it or not.
I have not been as fortunate as you.
Yeah, I've never encountered it myself. So look, there are, let me start off with the ethical rules, because that's really key here. And you know, the crime of suborning perjury. So a lawyer cannot, under any circumstance, condition, or set of facts, proffer facts that he or she knows to be untrue. Just can't do it. Now, how do you do it, right? So a defendant has a right to testify at a trial, and
it's his or her choice entirely. You don't make that decision.
Right.
I think that's where some of the problem comes in for the lawyer, because if the lawyer thinks they're not going to tell the truth,
right,
but we don't make the decision.
Right.
So how's that work?
So what we do is, you know, these are decisions and conversations that you have well before a trial starts. But you know, because you've tried a ton of cases, you don't know how a trial is going to evolve. You could have, you know, a great handle on facts. You could have a great handle on the law. You can understand and prepare, direct and cross and execute brilliantly, but you don't know how things are going to evolve. And the decision to call a client can only be made at that very time during the trial. Now, getting back to your question about a client that's going to lie in a witness stand, the rule is as follows. You can't, quote, elicit false, untrue testimony. So how do you do it when a client wants to testify and you know the client is not going to tell the truth? First off, you explain on the record, out of the presence of the jury, that it is my advice as the lawyer that this defendant not testify. It's a strategic advice, a strategic decision that I have offered to the defendant, and obviously judge the defendant is a decision that he has to make or she has to make personally, and he has decided to do it. and let the record reflect that this is not something that I am suggesting should take place. My opinion is that the defendant should not testify. Defendant goes on the witness stand, and one statement is said to the defendant: tell the jury your view. That's it. Then a lawyer sits down. It's a one-question narrative about the whole case. Because once you start asking particular questions that are now eliciting false statements, then you run into a problem. So that's the compromise between a defendant's right to testify and a lawyer's obligation not to elicit false testimony, right?
Well, interestingly, Tony, in the Pelosi case, and I have the transcript, as you know, we know that the lawyer who tried that case for the defense was a very competent, well-known attorney and was well aware of the rules in terms of putting his client on the stand. And he likewise said to the court, that Mr. Pelosi has chosen to take the stand. And this was a murder case, for those of you who are not aware, but it was a very, very dramatic murder case. And basically, the judge asked the lawyer whether he had explained to the client, all the ramifications, et cetera. And the lawyer didn't just say, Mr. Pelosi, what's your position? Or what would you like to tell the jury? He said, were you in East Hampton on thus and such a night? Were you involved in the murder? It's 5 very brief questions, but there were questions. Do you view that as troublesome in any way?
Well, I did represent Danny Pelosi on other crimes besides the murder, so I know Danny Pelosi very well. And Danny Pelosi was his worst enemy.
Of course.
He can keep his mouth shut, and he'll tell you that himself. And I know the struggles that his lawyer went through, because I'm aware of that as well. I think that lawyer, who has since passed away, unfortunately, terrific lawyer, and he crafted those questions very, very carefully to avoid problems for himself. Sure of that. Now, I will say that the direct testimony, because I actually watched that, he actually did pretty well on direct testimony. The problem that Danny Pelosi had is that he was cross-examined by a terrific prosecutor who you and I both know, who just undressed him and cross-examined him on previous psychiatric reports that he had to endure on his worker's disability, where he himself called himself unpredictable and stretching the truth and personality disorder. So it's just, it hardly ever works well for a defendant to testify. Out of the numerous cases that I've tried, I can count the number of times on my right hand how many times I've called the defendant to testify for good reason.
Unless you may have an affirmative defense.
Yeah, well, then you're going to have to do that. But
Can you
what
explain
happens is that I'm sorry?
Can you explain what an affirmative defense
Sure.
is?
So an affirmative defense is basically admitting to the facts of what happened, but you're falling on a legal defense. For example, self-defense in a murder or an assault, right? You're allowed to use deadly force upon somebody if, 1, you're not the initial aggressor, and 2, you have a duty to retreat and you didn't. You had a duty to retreat and you couldn't, and you had a reasonable understanding that deadly force was going to be used upon you. Then you're allowed to use deadly force. You can't get that across to the jury without a defendant testifying. I mean, you can call witnesses to explain what they saw and what they heard, but to hear it from a defendant on a self-defense case is essential. There's other affirmative defenses, duress, for example. You're forced to do something, you had no choice. But it's typically not a good idea, because what happens in a juror's mind, and we all know this as law students and lawyers, right? The prosecution has a very, very high burden of proof in proving a defendant's guilt. It's beyond a reasonable doubt. And there's a presumption of innocence on a defendant, right? Defendant doesn't have an obligation to put forward evidence. And a prosecutor has a huge burden to prove guilt. Once you call a defendant to testify, they're going to micromanage that testimony. They're going to just pick out certain words. They're going to overanalyze the manner in which someone said something, his demeanor up there, the words he uses, his facial expressions, his tone, his intonation. And what happens subconsciously to jurors is it's burden shifting. Instead of now having the burden on the prosecution, the burden in their mind is, well, the defendant, was he telling the truth? If we don't think he did, then he's guilty. So it's really a tough call sometimes. But when there's doubt as to whether a defendant should testify or not, you err on the side of caution, in my view, and you don't do it.
So what percentage of your cases would you say your defendant has testified?
Very few. I had a double murder case last year that we called the defendant to testify at the grand jury on a justification defense. It was a house party where his brother was getting beaten up by a group of party goers that crashed a party from the city that we found out were gang members from the Bronx that were pummeling his brother badly. And he grabbed the knife from his car and he killed 2 people. And we had him testify before the grand jury, and they came back with no true bill. They didn't find any criminal liability. They excused the 2 murders based on self-defense of his brother. So very rarely do you come across that. But when you do, you got to be careful. You got to prepare your client, and sometimes it works.
Well, I think at this point, Tony, I want to say just a few words. One is how fortunate we are to be able to sit here with you for this period of time and have you, tell us and answer anything I've thrown out to you. So I really, really appreciate that. And just for those of you who are not aware, Tony teaches at Touro Law Center, and he teaches obviously things in the criminal area as well as some trial practice courses. I have worked with Tony. I teach most of the trial stuff at the law school. And Tony is one of our coaches in our trial competitions, along with the lawyer he referred to earlier who took apart somebody on cross-examination. And so we are extraordinarily lucky to have somebody like Tony as a professor at the law school, but as a representative of what a good lawyer and a fine lawyer should be, and that he believes in our system and he acts on what he believes in. So thank you so much for being with us, Tony. It's been my pleasure to spend this evening with you.
Lynn, anything for you. How many times have I told you that? I adore you, and I adore our great law school, and I'm more than happy to help you anytime.
Thank you so much.